Hello, good morning. Today, I'll be sharing on indefeasibility of title. Okay, it's an important issue that has always crop up. Okay, pertaining to ownership of land. Okay, this is a concept under Section 340 of the National Land Code. Particularly, we are going to see the application of the Proviso. Okay. What Proviso I'm talking about, we will go down, okay, to refer. Okay, when I talk about indefeasibility of title, okay, the word indefeasibility comes from the word defeat, D-E-F-E-A-T, okay, meaning that you can be defeated, boleh dikalahkan, can be set aside, can be challenged. So when we talk about indefeasibility of title, it's something that you cannot be defeated, you cannot be challenged, you cannot be set aside by the courts. Okay, it is a concept recognized, okay, in our country through the torrent system. The title to the properties registered in the name of a proprietor cannot be defeated. So when you go to land office, okay, those doing the real estate, okay, you do land search, right? So you do land search, and the name of the owner appears on the title, right? If it says the owner belongs to ABC, that is it. Okay, the title shows that ABC, so ABC is the owner. Okay, but okay, there are circumstances where title can be defeated. Okay, it can become defeasible. So before that, we have to understand what does Section 340 of the National Land Code provides. Okay, you have to understand, okay, the provision of this section. Each of the subsection, okay, will be crucial to determining the title belongs to who. Okay, whether that person is as registered as you see in the title land search, the land belongs to him or not. Okay. So subsection 1, it says that the title or interest of any person or body for the time being registered as proprietor, okay, will be indefeasible. Okay, so when you see the name as appear in the land search, that is it. That is the owner. Okay. But subsection 2, okay, the title of such person, such who refers to who, such refers to that the name that you see in the land search, shall not be indefeasible in these circumstances. Okay, A, fraud or misrepresentation, okay, to which the person was a party or privy. Okay, B was registered, obtained by forgery or void instrument. Or C, where the title or interest was unlawfully acquired by the person in the purported exercise of any power or authority conferred by any written law. Okay, subsection 3, okay, where the most controversial one, where the title or interest of any person is defeasible by reason of subsection 2. Okay, so that title will be liable to be set aside, okay, in the hands of those who may be subsequently be transferred to the subsequent purchaser. Same goes to the interest. Any interest that was granted will also be liable to be set aside. When I talk about interest, it refers to interest such as charge, easement, lease, all that is interest. Okay. Now, this is the proviso that create a lot of problems. Okay, nothing in this subsection shall affect any title or interest acquired by any purchaser in good faith and for valuable consideration. Okay, okay. So this, okay, so the issues, okay, that has been cropping up in court for year after year until now, there's no solution to it. Okay, when you invoke the proviso to section 340 of the NLC. Okay, what has been approach that used by the court, okay, to determine whose land is it? There are two ways of interpreting this section. Okay, as you can see in the screen, section 340 on the left side, okay, is the same provision that I read just now, okay, but I just put it in short form. So you see at the left side, the proviso is separate there. Okay, there's a space there, provided that nothing blah blah blah. Okay, good faith and for valuable consideration. And on the right side, okay, you see the line there. Okay, separating this one subsection 1 from subsection 2, and between subsection 2 and subsection 3, there's another line. So what does that line mean? Okay, why this left one no line and the right one got line? What does that mean? Okay, so section 340, for the approach in the left side, where there was no line, what it means is that this approach has been used in the case of Adona Properties and Bunsung Bunyanit. Okay, I believe those who have studied at CLP would have heard this case many times. Okay, this is a landmark case, but too bad. Okay, the original purchaser, the original owner lost the title because of the approach that the court used in the left side here. What it means is that, okay, it doesn't matter whether you are fall under 2, or doesn't matter as you are fall under 3, okay, where the title was subsequently transferred. As long as you can prove your good faith and for valuable consideration, you will get the title. This was the approach, okay, used by the federal court in Adona Properties and Bunsung Bunyanit. Okay, what happened in that case was that there was this Bunsung Bunyanit, a Thai citizen. Okay, there's actually two. Okay, two Bunsung Bunyanit. This belongs to this real Bunsung Bunyanit. Okay, then this fake Bunsung Bunyanit, also the same name, okay, but different passport number. Okay, forge this signature of the real Bunsung Bunyanit and get it transferred, okay, to Adona Properties. So Adona Properties, okay, which is the new proprietor, he was challenged. His title was challenged by the original, by the real Bunsung Bunyanit. But okay, this Adona Properties got the title. Okay, in this case, okay, because he got the title because he was able to prove there's bona fide and for valuable consideration. He bought the money, okay, and he has no notice of the fraud. Okay, so that was the so what happened is that in that case the court didn't determine, okay, whether that is this Adona is immediate or subsequent purchaser. Okay, so that case was heavily criticized, okay, until it come to 2010. Okay, there's another federal court decision that overrides this, okay, that reverse all this principle in Adona Properties. Okay, when you see Tan Ying Hong, okay, so it applies a different approach, which you can see in the right side. So subsection 1, of course, no issue lah. The title, by right, when you do land search, the title appear whose name, that title belongs to that person as appear in the title. Okay, so subsection 2, okay, where the title was obtained by ABC. A is fraud, B is forgery, hereby instrument, and C is under any written law, as I read earlier, right? So there was a line here, right? So what it means is that in subsection 2, if you fall under that, you are an immediate purchaser. If your title is obtained by this, by right, your title has no, you have no good title. Your title will be defeasible. Similarly, any interest that created through this will also be defeasible. Okay, when you see there's a line there, the proviso doesn't kick in. If you are immediate purchaser or immediate interest holder, you see the proviso is only at subsection 3 below, right? So if you fall under 2 as an immediate purchaser, you will not get protection under through the proviso. The proviso only comes in if you are a subsequent purchaser, which is in subsection 3. Okay, so Tan Ying Hong make that principle, so it totally reverses what was in Proviso earlier. So clear, okay. The proviso only comes in if you are a subsequent purchaser. So when you determine this case, okay, determine cases that comes in, okay, whether let's say the charge, you created charger, then come to us, is my charge created good? Okay, so you have to first determine whether the person who created that charge, which is the owner, okay, is an immediate purchaser or a subsequent purchaser. That's the crucial question. Okay, you have to first determine of everything whether is immediate or subsequent. So immediate, then too bad, so you fall under subsection 2, you get caught under subsection 2, where you are not protected by the proviso. And subsection, if you are subsequent, then you can invoke subsection 3 and the proviso, provided you can prove your good faith and for valuable consideration. Right? So this is the version that I was explaining just now. Okay, the version in the left and version in the right. Okay, this is the version in the left, as in the Adona Properties and Proviso. And the second version is in the right, okay, that I've explained. Okay, so it makes a clear difference between an immediate and also subsequent. So you must first determine whether that owner, okay, is an immediate or subsequent. Okay, this is the Tan Ying Hong case referred to another court of appeal. It doesn't go to federal court, this OCBC bank, but this OCBC bank, okay, Anish Chan justice made a very important principle here. They observed a very important principle. What it says in OCBC bank, okay, because this one involved charge. The issue is not so much of a transfer. The issue always revolve around bank, the charge created by the bank. Always there's the difficulty, okay, judge to decide whether the charge held by the bank, okay, the bank is an immediate or subsequent. Now, if immediate, habis lah, okay, your charge will be void. So in OCBC bank, The charge held by OCBC Bank, it was held that it's void. Why? Okay. So the rationale, why immediate purchaser cannot invoke proviso, while subsequent interest holder can invoke proviso. Okay, you must be thinking that, okay, if you use number 2, then the charge are very, the chargee is very unfair to a chargee, right? Okay. So the rationale found in OCBC case, why the bank, that OCBC Bank, okay, who held the charge as a chargee, okay, his title, the charge is indefeasible. The charge is defeasible. Okay, because what happened in the OCBC case, there's one original owner is Ng. He obtains. Oh, no, okay. Ng obtains registration from the original proprietor. Okay. Ng is the first, okay, through a forged power of attorney from the original owner. So Ng did not transfer. Okay, but instead he go and obtain loan from OCBC. So you obtain loan, you must create a charge, right, as security. So created a charge in favor of OCBC. So what is the position of OCBC? OCBC is a subsequent or immediate purchaser. Okay. The Court of Appeal decided that Ng was an immediate purchaser. So to determine whether OCBC is immediate purchaser, you must look at the person who created that charge. So Ng was an immediate purchaser. Okay. He got the title through void instrument. So he falls under subsection 2 of the section 340. So when he has no title in the first place to create a charge, so the rationale used in the OCBC case, why OCBC, okay, is an immediate, because this charge held by OCBC was created by Ng, who was an immediate purchaser. So the principle was that an immediate purchaser can only create an immediate interest. A subsequent purchaser can only create a subsequent interest. Okay, so that's the principle that was also adopted in Tan Ying Hong. Of course, in the case following that, okay, the facts are not so clear-cut. Okay, not all facts that you come across is so clear-cut that you can determine who is purchased, who is the immediate, and who is subsequent. Okay, so you have to see the facts. Okay, each case you have to see facts like that. But that is the principle. Immediate purchaser can only create immediate interest. Subsequent purchaser can only create subsequent interest. Okay. Whether this principle is applicable in the following cases, okay, we shall see. Okay. Okay. This is the ratio that I use lah. Okay. That I referred just now. Since a forged instrument is a nullity, it does not confer any right or title on the land. So a person who has no right or title on the land in the first place has no right to charge it, because the land is not his in the first place, for him to grant any interest in the land to someone else. It makes sense to me. Okay. So too bad for OCBC. Okay. As an immediate purchaser was proven to obtain title by void instrument, his title was defeasible. So of course, any charge interest that created through him, it must be defeasible as well. Okay. So Tan Ying Hong, the facts similar to OCBC. Okay, OCBC comes first, then only Tan Ying Hong. OCBC is in 1999. Tan Ying Hong is in 2010. Okay, same. Okay, Tan Ying Hong also held that also same. Okay, they got this to act under power of attorney, this Tan Sian Son, and charged the land to UMBC to secure loan. UMBC was also, in Tan Ying Hong, UMBC was also an immediate interest holder. Okay, so this is what the federal court held. Okay, rebutting the facts of the case is not in dispute that the two charges in favor of the third respondent, which is the chargee, was based on void instrument. Okay, 16A was not executed by the Tiny Hawk. So that goes, okay. So there's the rationale is that the chain of title, okay. So when it subsequently it was transferred, no good title transferred, no matter how many times, it by right it should be divisible. But subsection 3, why the proviso comes in, is actually I can tell you is a policy reason. Okay, it's to protect bona fide, subsequent bona fide purchaser. Otherwise, you have no certainty of title. After spending 100,000 or a few 100,000 to buy a house and get a loan, then you have to tie to the loan for how many years, and you end up, the land is not yours. Then who dare to buy property? Okay, so there's certainty. So the National Land Code recognize this is what called deferred indefeasibility. Okay, when you subsequently transfer, you can prove indefeasible, provided you can prove good faith and for valuable consideration. So that's the principle. That's what we understand by deferred indefeasibility. Okay, this was what was held in this. Transferred. Okay, interest holder was position. This one I've gone through just now. All right. Okay, after Tan Ying Hong, then we get okay, subsequent cases may not all subscribe to the OCBC principle as I created just now. What they do is that actually before this TCVAM, there's another but I follow the flow. So TCVAM is also another federal court decision. The cases I'm going to refer after this is all federal court. But even federal court judges, they could not decide. They could not unanimously decide who's an immediate, who's a subsequent purchaser. So this TCVAM is a bit different from the Tiny House case. Okay, what happened is that the original registered owner, his son, fraudulently transferred the land to himself, and then this son go and get loan from public bank. Okay, the charge was created and registered in favor of the bank. This facts same as Tan Ying Hong, but the principle that they want to emphasize from this case is not so much from immediate or subsequent, but it's the definition of good faith. Okay, what is good faith? Okay, so this facts are a bit peculiar because federal court held that public bank is the subsequent interest holder. You see, okay, same facts as just now. Okay, but ini public bank is subsequent interest holder because you know how they get this subsequent interest holder? They play with the words purchaser. Okay, this case, okay, they decide that purchaser includes charge. So if that is the case, this loan transaction, that comes after this is a subsequent transaction. Just because it comes under subsequently to this transfer, this is a subsequent transfer. This is subsequent purchaser. Public bank is a subsequent purchaser. So I personally do not really agree with the decision of this. But anyhow, for principle sake, for discussion sake, I will just refer to this case. Yeah. The deceased discovered the fraudulent charge, and creation of the charge. So he commends, action, set aside the fraudulent transfer. So High Court, the chargee bank, public bank was, and it heard that it was immediate holder, followed by the case, and so could not claim protection. But it goes to Court of Appeal. The chargee bank is a subsequent interest holder. Okay? As to whether it can claim protection, this is because even you are subsequent interest holder, it does not automatically get the land, right? You still have to prove that you are bona fide and also for valuable consideration. Failing which, if you are unable to prove these two, your title will still be defeasible. Okay. So the court found that in this case, there's this common solicitor. Okay, so when the son fraud, commit fraud on the father, the transfer was done by this so-called solicitor. Okay, and this same solicitor, okay, do the loan transaction, the loan documentation for this son, okay, who obtained the loan from public bank. Okay, so the court in this case impute that the knowledge of the solicitor, the common solicitor, of this dispute as to ownership of the title will be imputed to the bank. That means, okay, even though this solicitor does not expressly go and tell bank, public bank, look, there's this, okay, but the knowledge of this solicitor is deemed to be the knowledge of the public bank. So there goes the title. So public bank's charge. Public bank is, although being a subsequent purchaser, there is because he can't prove good faith, and he can't prove good faith, so they lost the charge. Okay, the charge was defeasible. Okay, so he went to federal court. He upheld the decision of Court of Appeal. Okay, so the chargee is a subsequent shoulder whether they can claim, they can't. Okay, so they can't prove good faith. So what is the meaning of good faith? When we say about section the Proviso. According to an earlier federal court decision, okay, so the mere knowledge of fraud would negate good faith. Okay, so this is very dangerous, okay, for banks. And if negligence, okay, or carelessness, negligence is also negate good faith. So good faith, they have a very strict application. What is good faith, right? So the federal court laid down the elements required to prove the existence of good faith. Okay. Good faith does not simply mean absence of fraud, deceit, or dishonesty. It requires acting honestly, reasonably, or fairly. So this includes taking ordinary precaution that ought to be taken. And the elements of good faith are not closed. So you have to see facts of the case. In all cases, depends on circumstances. And it's not enough for a purchaser to merely show the absence of fraud. There's no fraud, there's no dishonesty. So knowledge of the dispute as to ownership, as in this T-Sibam case, would vitiate good faith. It would negate good faith. Okay. Similarly, carelessness as negligence also negate good faith. So it's quite difficult to prove this good faith. Yeah. So the federal court in Indefeasibility set aside the charge because it's defeasible. Okay, and held that the bank did not acquire the interest in good faith. Okay, these are the grounds. Okay, because mainly is because of the knowledge of the common solicitor that there is a serious dispute as to ownership. Okay, so and also that this transaction will immediately after transfer they get the land. So these were closely connected. The lawyer could not say that they get, because it was back to back. All right. So in the light of the fraud allegation which the chargee is regarded, okay, there's a real necessity for the chargee bank to conduct further. Okay, this is what the bank should do, but the bank did not. So in the face of these suspicious and uncertain circumstances, Still, the bank failed to make further inquiries before creating the charge and disbursing the loan. Okay. In Raja Money, okay, this was before this T-Sigam. Okay, it also went to federal court, but this court appeal, when in court appeal, it merely departed this Tan Hong's principle. What it says is that if this title is void, how many times the transfer is also void. Okay, but luckily it was reversed in federal court. Okay, the federal court reaffirmed the principle in Tan Hong. Okay, if you are subsequent, as long as you're a subsequent purchaser or subsequent interest holder, you will get good title provided you can prove good faith and for valuable consideration. CIMB Bank and Bank Berhad also 2007, that's before T-Sigam. Okay, they also split views. Okay, because this decision also 4-1. Okay, there's one dissenting also. What happened in that case is that this Chin Tin Seng, these two Chin, were owners of the piece of land. They charged the property to CIMB. Okay, so at the same time, there's also this Wong also create charge on this same property to MBank. So you see how come, right? So it was what was that this Wong, okay, forged the document on discharge. Okay, discharge of charge means discharge from the first charge, which is the CIMB. Okay, and he created charge, transferred to himself, and then created a charge in lieu of MBank. Okay, so okay, so it discovered there was two titles over the property, okay, and the discharge of charge. So when you face with titles, this also can be one of the ways that they create fraud. Okay, the lost title and then the new title in a different name, and then they transfer. So when you face with a lost title, you have to be very careful. Right? Okay, so the court held that the MBank, okay, which is the latest chargee, okay, is an immediate or subsequent purchaser. Okay, so in the High Court, it says it's immediate. Okay, it follows the Tan Hong and OCBC case. So immediate, there was forgery by this charger Wong, so the title defeasible. Okay, but in the Court of Appeal, it was reversed. It said MBank is a subsequent purchaser. Okay, and then subsequent purchaser can prove good faith, the title goes to the charge by MBank is good. So of course CIMB appeal to federal court. Okay. What it says, okay, there is a very important principle, which is there is a very important question. Okay, chargee, okay, comes within the meaning of purchaser. That means does purchaser includes chargee? So federal court said yes. Purchaser includes chargee. So if that is the case, so every transfer is charge of charge and then creation of charge, transfer and then creation of charge to MBank, that makes Wong, okay, in becoming a subsequent purchaser. Okay, so that's how they play with the words. Okay, so it's very dangerous when you include chargee as a purchaser, but that was what was decided lah. Okay, so that's why you have federal court 4-1. The decision is that MBank is a subsequent purchaser. Okay, so as they have no knowledge of this forgery, so they prove bona fide, so they get the charge. Okay, but of course there's one dissenting one lah. Okay, dissenting Judge Jeffrey Tan. Okay, they say MBank is immediate purchaser, so the proviso is not applicable. Okay, for me personally, I subscribe to what Jeffrey Tan. Okay, because I hold back to the OCBC principle, and then Wong is an immediate purchaser, the charge created by him to MBank would be an immediate interest holder, not immediate purchaser. So I can't, okay, I don't really agree with purchaser includes chargee, right? So that's my opinion, okay. But this is the, okay, there's been the provision, the decision of the federal court. So it looks like the current position is still not clear, okay, because 2000 every year it's been 2016 one, 2017 one, 2018 one, 2019 also. Okay, I expect this year there will be another, okay, on this issue. Okay, so this issue will be revolving again and again as long as this problem on the subsequent and immediate issue does not resolve. Okay. Okay. Moving forward. Okay. As especially like for chargee banks. Okay, they would want to know um, how how they can avoid. Okay. How they can prevent this okay, when the security that created in favor of them being lost, being because the title is defeasible. Okay, actually 2 years back when I attend Shalam session, okay, there's a session on sharing on this, okay, by speaker. There's no concrete answer on this. Okay, there's hard to it's actually hard to detect, okay, where does this fraud comes from. Let's say if the land really get transferred to this fraudster, how are you going to go beyond that and to check whether this fraudster is the real owner or not, or where he got that title? So there has been discussion. I mean, there has been suggestion, okay, through the cases that one of it is that there should be a requirement when every time transfer in the land office, both the vendor and the purchaser should attend before the registrar. I don't know how this works. Okay, so far it's not been implemented. Okay, but practically how does this going to work? Okay, is yet to be seen. And also creating a fund, okay, to compensate this original owner who lost the land to subsequent purchaser. So that's also, okay, this actually also just a suggestion. There's no moving forward because there'll be issue. Then who manage this fund, and where does the fund comes from, where the money come from? Okay, excuse me, right? Okay, so I think maybe solicitor, common solicitor as in T. Sivam, okay, or ideally they will not use the same common solicitor. Okay, maybe to some extent that would help, right? At least the knowledge there could not be imputed to the bank, right? And okay, this is the one. Okay, so who is not privy to previous dealing? Okay, at least got some excuse, okay. So that has been some suggestion lah. So as far as I know, there's nothing concrete yet. Okay, but if there's anything, okay, any suggestion that you feel that is workable, feel free to yeah, let me know. Okay, I would be interesting to know that, right? Right. So thank you for participating in the session.